Okay, once again, so sorry for the break in transmission. It was due to some technical issues with the network provider. We hope and pray that this interruption will not mar what we have set out to achieve today. So let's proceed. Today we are going to take a look at the various facets of legal issues bordering on the rights of landlords and tenants in the Enugu state of Nigeria. We have to take a look at the ambit of landlord-tenant relationship in the Enugu state. Then the position of the law on who qualifies to be a landlord and tenant. We are also going to look at the nature of tenancy recognized by law in the Enugu state. Then the terms and conditions expected to be part of landlord-tenant relationship. Then the legality of lawyers and agents being involved in the creation of tenancies in the Enugu state. Then duties and responsibilities of landlords and tenants when a tenancy is being created. We shall also look at biases and prejudices against landlords and tenants. And finally, we have to take a look at the issue of rent. So let us proceed because we have a whole lot of things to cover today. First of all, talking about the ambit of landlord and tenant relationship in Enugu state, we should appreciate the fact that there is no uniform law that governs landlord-tenant relationship in Nigeria. In other words, the law that applies to landlord-tenant relationship in Enugu state differs from what obtains in other states of Nigeria, because issues bordering on the rights of landlord and tenants are issues that fall within the concurrent legislative powers of lawmaking in the Nigerian constitution. You know, we have the exclusive concurrent and legislative lists. So the federal government has powers over exclusive lists, in which case the National Assembly can make laws over such matters. The state governments have powers to make laws alongside the federal government in issues that fall within concurrent legislative lists, while the state government also exercises powers over what we refer to as residuary lists, being lists that do not fall within the exclusive and concurrent legislative list. But basically, the laws that govern landlord and tenant law vary. These laws vary. Now, that of Enugu state, the rights or the relationship between landlords and tenants is being governed by the provisions of the Landlord and Tenant Law of Enugu State of 2004 as amended. Interestingly, this particular law does not apply to states like Lagos, or maybe to the Federal Capital Territory, Abuja, or even some other neighboring states. It's only applicable to Enugu State. So the first thing you should know when you are taking a look at the rights of landlords and tenants, that you must have to fall back to the provisions of the law governing this particular relationship in Enugu State, being the Landlord and Tenant Law of Enugu State. We also know as a fact that we have the basic law, what we refer to as the ground norm in Nigeria, which is the supreme law of the land, referred to as the Nigerian Constitution. The provisions of the Nigerian Constitution also regulates the rights of landlords and tenants in Enugu State, even though this particular ground norm does not deal specifically with this area of law. But there are some rights that the landlord may enjoy, like the right to property. Likewise, there are some rights a tenant may enjoy, being the right to the dignity of human persons. These rights are constitutionally recognized rights enshrined in Chapter 4 of the Nigerian Constitution of 1999 as amended. But today, basically, we are looking at the provisions of the statutory law, substantive statutory law that regulates the rights of landlords and tenant relationship in Enugu State. Now, there's a striking point to be noted about this particular law in Enugu State. It applies to all forms of tenancies except for tenancies couched in accordance with the provisions of customary law. So if there's any tenancy relationship that was entered into by a landlord and tenant in Enugu State, pursuant to the provisions of a customary law that applies to the part of Enugu State, then the provisions of this particular law will become inoperative. But to a greater extent, the various relationships between landlords and tenants in Enugu State are being governed by the provisions of the Landlord and Tenant Law of Enugu State of 2004 as amended. So this is the ambit of this particular law the wide coverage of this law vis-a-vis the various rights, duties, responsibilities, and obligations that landlords and tenants shoulder in Enugu State. Now, there is another vital point to note. For a landlord-tenant relationship to come into existence in Enugu State, there must be a property. And that property will be the subject matter of that relationship. In other words, for one to claim to be a landlord, one must have rights, what we refer to as right of occupancy over a given property. And also, for one to claim to be a tenant in the Enugu State, one must also have what we call possessory rights over a given property. What do I mean by possessory rights? In law, it is said that he who is in possession enjoys some level of protection. What am I trying to say? I may not be the owner of this property, yet because I'm a tenant in this property, I enjoy some rights because I'm in possession, because I live here. In other words, the landlord of these premises, there are certain things he cannot do to me, despite the fact that he is the owner of this building, while I'm a mere tenant. Why? Because I exercise possessory rights. I'm in possession. I'm in occupation. That is why, in the true sense of it, even a trespasser enjoys some protections in the eyes of the law in any good state of Nigeria. If we are talking about law, we are not talking about restore to self-help. In other words, there are laid down procedures to be followed in ejecting a trespasser in any good state of Nigeria, as far as the landlord and tenant law of Enugu State is concerned. And if you are talking about property, the property mustn't be a complex property. Once the property is in a state, in a fixed state, in which that particular property is placed at a particular location in Enugu State, wherein the person referred to as a tenant will always visit on an intermittent basis, either for the purpose of having that place as his place of abode or for business. In other words, those who carry out their businesses in makeshift containers, in the eyes of the law, will be deemed to be the tenants of owners of the land where such makeshift containers are kept. Even though they are not permanent structures, they are in reasonable fixed states. So in the absence of a property, landlord and tenant relationship cannot come into existence. Even land, there are some situations whereby a landlord and tenant relationship will come into existence once the owner of a land lets another into possession of an empty plot of land or empty parcel of land, because that land is also a fixed property, subject to the terms and conditions that parties may decide to govern that particular relationship. A tenant could exercise some possessory rights over that particular land. So there must be a right of occupancy in place in the first instance. And the person to be referred to as the landlord is the person who enjoys that right of occupancy. In law, we have what we call statutory right of occupancy. We also have what we call customary right of occupancy. But that's not the topic of discussion today, because the issue of rights of occupancy, they fall within the ambit of land law. But the vital point we should know is that in law, nemo dat quod non habet. This is a Latin maxim. In other words, it means that you cannot give what you do not have. I cannot claim to be your landlord when I don't enjoy a right over this property. I can only claim to be your landlord when I enjoy the right, when I enjoy a right recognized by law over this property. For instance, if this property is bequeathed to me by a will made by a testator, testator is the person who makes a will, then automatically I will enjoy some rights recognized by law over this property, in which case I will not be empowered to give another person a portion of that my right, to stay as a tenant, subject to some conditions which will be met by the prospective tenants. So this is the major ambit of the land and tenant relationship in the Enugu State of Nigeria. Having said that, we move over to the second issue, which is the issue of those who qualify to be landlords and tenants in Enugu State. I have hinted, I've commented briefly on this issue. But in the first instance, for one to be a landlord, one must be an adult person in Enugu State of Nigeria. An infant cannot be a landlord. In other words, one who is under the age of 18 cannot be a landlord in Enugu State. Now, I know some people may be confused the question may now arise. Assuming a property is bequeathed to me by my father and I'm a minor, I mean, I'm not up to the age of 18, and my father gives this property to me, does it mean I cannot enter into a landlord-tenant relationship with a tenant or with a prospective tenant if I now claim that a minor cannot be a landlord? The way to go about it is this. If a minor is the owner of a property and the minor seeks to enter into a landlord-tenant relationship with another person, the minor can do that through his guardian. You know, just like in contractual relationships, the fact that one is a minor does not mean that one cannot enter into contractual relationships, or that does not mean that one cannot sue. But the person, the minor, has to do that through his next of kin, through an adult person. In other words, a minor can enter into a contractual relationship that has the flavor of a landlord and tenant relationship through an adult person, but he cannot do that directly on his own. However, interestingly, on the part of a tenant, a minor can be a tenant. That's why I find some university students who are not up to the age of 18. Yes, they are admitted as tenants, you know, in some premises here in Enugu State. But there's a word of caution here. That word of caution is this: an agreement entered into with a minor can become voidable. When it is said that something is voidable, it means that that thing, in the eyes of the law, could be deemed to be valid, subject to the right of the person who is not qualified to enter into it to declare it a nullity. In other words, the same way a minor can enter into a landlord-tenant relationship through a guardian, likewise a tenant can enter into a landlord-tenant relationship with a landlord through his guardian as well, for such an agreement to be binding and for such an agreement to have the force of law. And one interesting thing about this landlord and tenant law in Enugu State is this: this law, to a great extent, is the codification of common law. Let me break it down the way we understand. We have various sources of law in Nigeria. We have what we refer to as statutory laws. Statutory laws or statutes are laws made by lawmakers. For instance, the landlord and tenant law of Enugu State is a law made by the Enugu State House of Assembly. You have a law, let's say like the Police Act. The Police Act is a law made by the Nigerian National Assembly. Whenever you hear the word act, they know that it's a federal legislation in Nigeria, as far as Nigeria is concerned. Then whenever you hear the word law, they know that it's a piece of legislation made by the members of the State House of Assembly. Now, we also have what we refer to as customary law. Customary law is the law that is common among the various indigenous Nigerian people. For instance, I'm an Igbo man from Enugu State of Nigeria. In my own part of Igbo land, being an Nkano man, we have various customs regulating the activities, you know, of Nkano people. Likewise, if you go to a place like Onitsha, you have the custom of Onitsha people of Igbo tribe that regulate the activities there. The same thing applies to all parts of Igbo land. Go to Abia, Imo, Nsukka, Ebonyi, you know, all parts of Igbo land. They have various customs. Even other tribes that are not Igbos, go to Europe, among the Yorubas, they have their various customs that regulate their activities. So these laws also have the force of law. Customary law is recognized in Nigeria, in as much as a customary law must not be repugnant to natural justice, equity, and good conscience. What am I trying to say? There are some customs that may be offensive to common sense, customs that may be against human conscience. Such customs will not be allowed to have the force of law in Nigeria. But that's not the topic of our discussion today, so let us not derail. The most important thing is that we have statutory law, we have customary law, we also have what we refer to as judge-made law. In fact, judge-made law, to a great extent, is the best form of law. Why do I call it the best form of law? Is that among all these other laws, whenever a dispute arises and that dispute comes to court, it is the prophecies of a judge, it is what a judge says to be the position of the law that will be deemed to be the correct position of the law. For instance, if you go to the Nigerian Constitution, it may say that Obi is a boy, but the case may go to court And because of judicial interpretation, the judge may actually say that Obi is not a boy, but that Obi is a man. And once a judge says that Obi is a man, that means Obi will be deemed to be a man and not a boy. That's why it is said that judgment law is the best form of law. Then we have what we refer to as common law, which is the one that catches our attention at this point in time. Common law in a nutshell is a law, a type of law that was operative in England, in the common realms of England. You know our history, that we are colonized by the British. During the colonial era, these laws, or this law rather, called common law, was also made to apply to Nigeria. You know, they used this law in governing the present-day indigenous Nigerian people. Now, we got independence in 1960. Upon gaining independence, our colonialists, they left us, our colonial masters, they left us. Yet, these laws continue being enforced. However, they continue being enforced subject to the existence of any statutory law. In other words, if before we became an independent nation, there was a law governing landlord and tenant relationship, upon gaining independence, any state that makes a law that governs landlord-tenant relationship, automatically, that law made by that state House of Assembly becomes the law that they recognize. The common law will no longer become operative. However, if there's any facet of our existence that has not been taken care of by any locally made law in Nigeria, common law remains operative. Now, having said that, it is vital to note that despite the fact that the landlord and tenant law of Enugu State regulates the rights of landlords and tenants in the Enugu State of Nigeria, what our lawmakers did was that they basically adopted common law principles and made it to become a statutory law, subject to few exceptions they made here and there, our lawmakers. And that is why, as I said earlier, what applies to Enugu State as far as landlord and tenant relationship is concerned differs from what applies to a state like Lagos State and most other western states in the western part of Nigeria or in the northern part of the country. Now, I have explained in a nutshell those who are qualified to be landlords and tenants in Enugu State. Now, having said that, we will now take a look at the nature of tenancy recognized by law in Enugu State. In a nutshell, being the creation of landlord-tenant relationship. One of the vital points we should note is that a tenant relationship can come into force by operation of law. It can come into existence by operation of law, a landlord-tenant relationship. It can also be by act of parties. Now, let me accord much attention to a landlord-tenant relationship coming into force by act of parties. I can enter into a landlord-tenant relationship with you orally. The landlord and tenant law of Enugu State allows that. In which case, I can tell you, okay, I am Mr. Chukwunonso Daniel Ogo, this is my property. Yes, I have a 3-bedroom flat to let at so and so rate. Now, as the prospective tenant, you come around, you inspect the property, you say, okay, I think I can live here. The property is in a good state. It's in tenantable condition. And I will now tell you, please, as the landlord of this premises, look at some modest rules and regulations regarding this property. People are not allowed to fight in my premises. We are not allowed to keep late nights. But if for any reason you have cause to stay late at night, please notify your co-tenants or notify the caretaker on time before coming back. If by the nature of your business you're coming back from work on a intermittent basis at odd hours, do let me know so that we can make special provisions for you, so that you have your own key to the access gate of the premises. In other words, I can enter into a landlord-tenant relationship orally by word of mouth. But there is a problem with this type of relationship. Whenever dispute arises between both parties, it may be difficult for the terms and conditions of this relationship entered into orally to be deciphered. I may deny accepting certain conditions or certain terms as the landlord of the premises. I may tell you that there was never any time I told you that